With growing concerns around Section 63 and Section 168 of the Electoral Act 2026, it is important we break down these provisions, truly what it means to us as voters and the credibility of our elections. So questions have been raised by stakeholders, including former INEC official Mike Ogini, have focused on rejected ballots and the grounds for election petitions, issues that sit at the very core of how voters are voting, how our votes are being counted, and how results are challenged. Are these provisions strengthening the process or creating more worries and bottlenecks? So today, we go straight to the source for the answers. We are joined by Adibaalugu. He's the chairman, House Committee on Electoral Matters, the lawmaker at the center of this framework. Honorable, you are welcome to Your View. It's good to have you join us from Abuja studio. Fantastic. Thank you for joining us. We want to start with why exactly is the Section 63 necessary?
Well, thank you for having me. Well, Section 63 is actually talking about the rejection of ballot paper without official mark. First, what is the official mark we are talking about? When a presiding officer wants to give a ballot paper to any voter, he stamps and signs the back of the ballot paper. What's the objective of this? We don't want ballot paper not allotted to a polling unit to be used at that polling unit. So at least your signature is at least personal to you. It could not be duplicated by the next unit. So every presiding officer is expected to sign the back. So if you have voted before, you would have seen this happen. Secondly, we don't want valid ballot paper to also be rejected. So if it does not have that signature, does it invalidate the ballot paper? That is different from the security mark on the ballot paper himself. Now, what we have in Nigeria now, the ballot paper we have now, are actually even customized. So if you have a ward A, every polling unit under ward A have their own number. You have unit 1, unit 2, unit 3. So in every ballot paper, you have the states, the local government, the ward, and the unit number of that unit stated on the ballot paper. So you cannot even take ballot paper from one unit to another unit again. Okay. So what we are saying is, if you don't see that signature, probably for one reason or the other, administrative error, should we reject such ballot paper? And that's why the second subsection was actually included. So the first section says, a ballot paper which does not have the official mark prescribed by commission shall not be counted. That is to ensure that we don't bring in fake ballot paper. And the second one says, where the returning officer is satisfied that that ballot paper, which does not bear that official mark, was from a book of ballot paper, that's a booklet of ballot paper, which was furnished to the presiding officer. If probably you have 100 ballot paper in a booklet, and we expect every unit not to have than 1,000 voters. So at least you are expected not to have more than 10 booklets. So if we find out that the ballot paper we are talking about, which is customized to that unit, belongs to one of those booklets that have been used, then you count it. So we don't want valid ballot paper to actually be rejected. And this is not a new provision. It has been there from 2010. And even now, when this provision was actually created, that was when they've not been customizing this ballot paper to those units. So for someone as informed as Mike Ogini to come out and wanting to distort the situation, for whatever reason he has, I don't know. Even the opposition themselves, some of them are very careful even touching this area because they know that it is a very wrong position that he is actually taking. But the reason he decided to do this, the commission you've worked for how many years, and this provision has been there and it has been used, and nobody has ever come out to say, no political party has ever come out.
So this is not new to the 2026 Act.
With this provision. So I think he has his own ulterior motives. That's all I can just say about this provision.
Okay. All right, thank you, Honorable, for this clarification. So with what you've said now, can this lead to more votes being discarded?
You said what?
I said, thank you for your clarification, but can this lead to more votes being discarded because of the rejected ballots? Yeah.
You see, in Kano election, the last 2023 election, this particular issue came to play. In Kano, they had many ballot papers that were not stamped. And that was the basis APC took NNPP to court. And at the Supreme Court, at the end of the day, it was determined that as long as those units, those booklets, those ballot paper belong to those units, then they must be counted. Because APC claimed that all those units, all those ballot papers should be rejected. And if that was done, that means by the time they removed those ballot paper, APC would have won that election. But because of this provision, NNPP was able to scale through. And that was the objective of this provision in the first place, to protect valid ballot paper, despite the fact that they might not be signed by the presiding officer. And if there's another subsection too, there's another section that talks about as long as the vote cast in any unit is higher than the accredited number of voters using the beavers, that unit must be cancelled. So there's a provision taking care of Essex votes in case any foreign ballot paper was brought in. So even if it is if you have 1,000 votes and 1,001 votes, and the accredited voters in that unit is 1,000, that unit must be cancelled. So you have a provision that takes care of that in a separate section. So we should not overheat this policy. We know the trust level in Nigeria is very low at every level, at the local government, state, and federal level. People don't even trust institutions in Nigeria. But when we have such a bad situation, we shouldn't worsen it. And a situation where issue of security is even so bad that even we as political officers don't even have any police protection, again, based on the directive of Mr. President, that the police should be put at the police station to take care of every one of us. It is very bad for anybody to instigate the public against any public official, because they could be taken personally too. He could even be sued.
Okay. So, are you still there, sir?
Yeah, I can hear you now.
Awesome. Okay. Mama 2 has a question for you.
So how do you prevent misuse at the polling units?
Let me actually take that question. Let me take you to section 138. Let me take you to section 138, because I would like to understand if
138. Okay.
Yes, how does section 138 limit election petition? Because there's worry that these changes that we're having is not really fine-tuning our process, but clogging the electioneering process. So please, let's have your opinion on section 138.
Okay, you see the difference, the issue with some people, some people have with section 138 is actually from the section 134 of the 2022 Act.
Oh.
In 2022 Act, there is 134(1)(a) says that a person whose election is questioned at the time of the election, that it talks about qualification of the candidates at any election, that you can petition based on the qualification of that candidate. But what we did in 2026, because some of those provisions were also stated in subsection 3, that it says that with respect to subsection A person is deemed to be qualified for an elective office, and his election shall not be questioned on ground of qualification if with respect to particular election in question he meets the applicable requirement of section 65 106, 131, and 177 of the Constitution, and is not also in breach of 66, 107, 137, and 182. What all this means is that while we are saying that a person can be petitioned based on qualification, we were referring to some of those areas that were mentioned in the Constitution that deals with qualification. But the issue now is if part of the areas that we listed from the Constitution is changed or amended, it will not be amended, it might not be amended in the Electoral Act, and that can cause confusion. So what we now decided to do was, as long as qualification is concerned, is a constitutional requirement. It is not by the act of the Parliament. So let's leave all areas that needs to do with qualification in the Constitution, so that if you have any issue, because some of them are not stated there. If you, for example, someone who has gone to jail is not stated under this subsection that we have written, and some other areas. So we said leave the ones in the Constitution, so that people who has any ground for disqualification of any candidate can always apply using the Constitution. So that is just what happened. It's just removing it from the Act and leaving it in the Constitution. Not that it has been stated that qualification should no longer matter in election. So it's just some people. I believe those people who are talking about this understand the issues, but they just want to make an issue out of it. But for clarity now, we are letting Nigerians know that the issue of qualification, which was under 134(1) before that was removed, was just removed from the Act, but it's still in the Constitution. So if you have any ground to petition any candidate or an aspirant on the basis of qualification, it is still valid. It is not just in the Electoral Act, but it is in the Constitution. So that's just the issue. So it's better we clarify that area, because what is being spread around is that the legislators have removed ground for petitioning based on qualification from the Electoral Act and from the electoral system. So that was they are trying to imply that we have removed it from the electoral system, which might also include the Constitution or any other law. It is only removed from the Act, but it is mainly in the Constitution, and the Constitution is the grand law. That is the head of all the laws we have in Nigeria. So anything that is not in the Constitution or the Constitution violates cannot be put in any other act. So I think we are still good to go as it is.
All right.
Yeah. Okay, so what safeguards are in place for voters, and also what are the ones that are genuine complaints? Are their genuine complaints still protected? What safeguards are in place for voters, and also their genuine complaints, are they still protected? What safeguards? What safeguards are in?
So because of what you have explained, it seems like the safeguards are. It feels like safeguards are in place for voters, but I want to know what those safeguards are, what the safeguards are, and if genuine complaints are still being protected based on this new act.
Which safeguard are you talking about?
The safeguards to protect voters. Do we have safeguards to protect voters?
Yes.
To voters?
Yes, so that genuine complaints can still be protected. So we want to find out, because you've already explained that the laws are there contesting against if there are complaints against a candidate, that the Constitution already protects that side of the electioneering process. So we're wondering if genuine complaints are still protected. That is already covered, but voters might also still want to be protected. So what are the safeguards in place for voters in the Constitution as amended in 2026? Electoral Act.
No, we are dealing with the Act, the Electoral Act, not the Constitution.
Electoral Act, yes.
The Electoral Committee can only amend the Electoral Act. It cannot amend the Constitution. But in all, we believe the essence of all these amendments is to protect the electorate and Nigerians generally, based on complaints brought forth by relevant organizations and stakeholders when we are actually having the town hall meetings, which we went through. We went through all the geopolitical zones. We consulted with various strata of the society, from gender groups to age groups to technical people who understand the system. We consulted with lawyers that deals with electoral litigations, the judges of the appeal courts, and security agencies. So this is an outcome of all these interventions and discussions with all these stakeholders. So I believe if anybody, like we said, law is never cast in stone. So if anybody has any genuine position that we feel, yes, that will still help out in trying to broaden our horizon as far as the Electoral Act is concerned, yes, we're actually going to welcome it. But if you bring forth something that we felt that, look, this thing has been taken care of, or you are just being myopic, then we'll let you know, look, this, whatever you are asking for is already in a particular section. Because sometimes we have this problem of people not even going through the whole sections. Maybe you just see one area and you pick on it and you don't even ask questions. But we are not too bothered about what even the political parties actually says in terms of maybe the opposition feel agitated or has an issues. Yes, they can always bring it up. But when people are supposed to know, like Mike Guinea, who was actually with INEC for so many years, comes out and decided to misinform Nigerians, that's why we have issues with.
Okay,
yes, even if the opposition decides to make the job of INEC difficult, well, it's part of the game. They can decide to say whatever they want to say so that to agitate people, but it's for INEC to defend themselves. It's the organization. But as far as this issue being propagated by Guinea is on the integrity of the Committee on Electoral Matters, because he said we deliberately put in dangerous provisions in the law that can mar the election in 2027. And that's why I have to come out and let Nigeria know that, look, there is nothing new in those sessions that you actually mentioned. Session 63 has been like that from 2010 up to today. He said they changed it in 2022. Let him go back and see what is there, and you can do that yourself too. Every journalist must also practice investigative journalism. So we must also look at it, issues ourselves. Go and check Section 63 in the 2022 Act and in 2026 Act. They are still the same. It was not even touched. The provision has been like that since 2010. So where he got that information from, I don't know. And
Thank you so much.
It's just a calculated attempt to agitate Nigerians and to make the government look bad in the face of Nigerians.
Thank you so much, Honorable Adibaalugu, Chairman, House Committee on Electoral Matters. Thank you for bringing clarity and disputing the claim that Michael Guinea had made earlier, because we just want to know that the elections will be good, free and fair, and you've shed light to the conversation saying that these sections had already been on ground before. No change was made in this current Electoral Act. So we appreciate you for bringing that clarity. We hope we can call on you if we need more information concerning the Electoral Act. That's what we can take on today's show. Thank you for your time. Thank you, ladies, for a beautiful show. We'll see you tomorrow. Bye.